and we're going to talk about those comments shortly. We also are opening up this meeting today to people who want to give us comments, and we do have 6 people who have indicated that they will be here to give comments. But before we do that, I just want to let you know that the report was adopted and submitted to the governor, the Supreme Court, and the legislature on January 15th, as we were directed in the executive order. Thank you all for your quick feedback and turnaround on that. We started taking the public comments on January 20th. We set up an email to receive those in writing, and Emily has put them together in a nicely digestible format, and we'll go through with all of us what we heard in that written comment period shortly after hearing from the folks who are showing up this morning. Before I turn to that next part of the agenda, the public comment, are there any questions or comments from council members? Okay, then let's proceed to public comments. I know that some of the folks were in the waiting room. The first commenter I have on my agenda is Philip Mayer from the ACLU. Phil, are you here? We can come back to Phil if need be. I'm assuming he's not in the waiting room, Emily?
It looks like he's here, Chief. Let's see if we can get him.
I'm sorry, I couldn't hear you.
I said it looks like he's here. We're just trying to get him unmuted here.
Oh, okay. Then I'm going to give you a second. There he is. Good morning, Phil. Can we start with your comments first? I should have said we have 6 people who have agreed to give comments. So sometimes when we have more than that, we have to limit it to 2 or 3 minutes. But I think we can probably go to 5 if that's okay with you. But we do have other things to get through on our agenda. So I'm hoping you can limit your comments to 5 minutes. Go ahead, Phil, when you're ready.
Thank you, Chief Justice McCormick. I want to thank the Advisory Council for the opportunity to address you this morning. My name is Phil Mayer. I'm a senior staff attorney at the ACLU of Michigan. In that capacity, I'm lead counsel in Ross versus 36th District Court, the class action lawsuit concerning unconstitutional bail practices in the 36th District Court in Detroit. And I've also represented defendants in other cases around the state in which courts have violated state law and the Constitution by the use of unaffordable bail. Over 2 years ago, I had the privilege of testifying before the Michigan Joint Task Force on Pretrial Reform. And at that time, we had recently filed the Ross lawsuit in Detroit. I began my remarks to the commission at that time by emphasizing one thing, that although we filed our class action lawsuit in Detroit, the problems of courts conducting unconstitutional bail hearings is without doubt a statewide issue, and one that I hear about when I speak to advocates in every corner of the state. I also indicated that the ACLU would be continuing to watch what happens in other jurisdictions when it comes to bail. Unfortunately, we've continued to see courts around the state flouting the United States Constitution and the Michigan court rules in imposing bail since that time. The failure by the courts to follow the law has become even more stark during the past 2 years as the COVID-19 pandemic has swept throughout the world, with particularly grim results in carceral facilities. The widespread presence of the pandemic inside Michigan's jails and jails' systemic inability to prevent its spread within their walls means that people improperly held pre-trial not just have their lives disrupted by being ripped from their families, their jobs, and their homes, but they now also face the risk that their pre-trial incarceration will become a death sentence. Furthermore, the extensive delays that have resulted from COVID-related court closures means that thousands of Michiganders have now spent years incarcerated pre-trial because of unaffordable bail. I've personally spoken with dozens, if not hundreds of people facing this plight during the pandemic. And unfortunately, all of the problems have had a predictably disparate impact on communities of color as well, a fact that is supported both by statistics in Michigan and around the country regarding pretrial incarceration, as well as by my own anecdotal experience. I'd like to share the stories we've heard demonstrating continuing failure of Michigan's broken bail system since I addressed the Joint Task Force. In Oakland County, I litigated a bail appeal in which the circuit court had imposed unaffordable bail after a defendant who was charged with felony firearm and intent to deliver fentanyl was late to court due to bus delays. Despite the fact that this occurred in the early days of the pandemic, the circuit court ordered this woman to be detained while awaiting trial, a decision that the Court of Appeals found constituted an abuse of discretion. A few weeks later, I litigated another Oakland County decision imposing unaffordable bail on a defendant charged with felony firearm. The circuit judge had reasoned that the lengthy prison sentence that the defendant potentially faced rendered him a flight risk. We appealed, and the Court of Appeals denied our appeal. We appealed again to the Michigan Supreme Court, which ultimately found the cash bail to be an abuse of discretion. Justice Kavanaugh's concurrence explained that a court cannot, quote, conclude that a defendant is a flight risk despite no history of absconding on bond or failure to appear in court, based only on defendant's presumed incentive to avoid punishment, an incentive present in virtually every case. We were pleased that the Michigan Supreme Court ultimately vindicated our client's rights not to face unjust pretrial incarceration, but the widespread problems of bail abuse in Michigan cannot be cured by the whack-a-mole strategy of appealing individual cases to the Supreme Court. And most defendants do not have access to the legal resources or to counsel who are equipped to bring such appeals. Yet another example, in 2021, we learned that a judge in Kent County was raising bond for defendants who had already been released pre-trial and who were compliant with the terms of their release shortly after such individuals reject plea bargains. Essentially, the judge was punishing people for exercising their constitutional right to proceed to trial. We appealed 2 such cases, and in both, the circuit judge was reversed. The Court of Appeals emphasized the law that money bail can only be imposed where a defendant's appearance to the protection of the public cannot otherwise be assured. That was a quote. Again, we're pleased with these victories, but this kind of patchwork appellate litigation cannot address the statewide problem. What could address the statewide problem is for the legislature to move forward with the package of bail reform bills that were introduced in the House last fall. Those bills reflect a comprehensive strategy to transform Michigan's pretrial practices and bring them into compliance with the Constitution and sound policy. We at the ACLU of Michigan continue to work with all involved stakeholders to move these bills forward, and I'm hopeful they will advance soon. However, if they do not, I fear that the next step will be for organizations such as the ACLU to turn back towards further federal class action litigation. I do not relish the time, cost, and concomitant disruption to court systems that such litigation can bring. Though I'm personally a litigator, I do believe these issues are best resolved through legislative reform. I urge the members of this council to do everything in their power to promote such reform and to help steer Michigan to a more just and constitutional pretrial regime. And I thank you for the work that you are already doing in that regard. Thank you for your time and your consideration of this vital issue. I'm also happy to submit a written copy of these comments today if it would be helpful to the council.
Thank you, Mr. Mayor. I would ask you to do that. We appreciate your being here and thank you for your thoughtful comments.
Thank you. Happy to do so.
Kevin Vaco is next. Kevin, good morning. I think you are muted, Kevin. Let's see if we can get you unmuted. There you go.
I did myself. Yes, I was, let me go very quickly here. I was a victim of pretrial incarceration on 2 occasions. I had submitted a written form to you guys, so you have that. But I guess just in my experience, my first intersection was they gave me a very unaffordable $50,000 cash bail. It was only assessed like almost as like what Phil had stated, was just based on a potential sentence going, well, he could spend up to 2 years in jail. And it was not, and it was supposed to at least based off of like, and the purpose of that bail, the original purpose of bail was to ensure that I returned to court. And so this had created judgment. I did not have the money for this. So I was held in there. And when you're held in such confinements, I have autism, and I not just to say that I want to make such a stark contrast against that, but I think a person with autism have far more significant sensory issues to that environment, especially with noise. That was a serious issue for me, and so that was a significant deterrent. And I'm very glad to hear that other a lot of attorneys, even prosecuting attorneys, have in the local area, Washtenaw County, Oakland County, have stated that they want to eliminate that cash bail. But even and then this affected me in the second instance where a police officer had made up a charge, and I was waiting for exculpatory evidence to come through. But in the meantime, they wanted to impose a tether condition, even though it was completely unnecessary, because if they had just simply had the evidence from the forthright, they would have seen that I was innocent. But they want me to wear his tether. I obliged for a while, and then they kept withholding this evidence, and there was an issue on the evidence where they got rid, even though I requested it very early on, saying I need this evidence. I have written documentation of that, and it went very sour because he couldn't wear a tether, and then the guy, like Phil mentioned another case, they held me in custody until that trial date. So in both those instances, because I'd suffered in jail for several months, I had suffered medical issues. And the second time I actually had developed gallbladder sludging and irritable bowel syndrome that has really paralyzed me even to this day. And this was 6 months ago. I got out, and but I was really forced to take a plea because I couldn't wait until trial, especially with the COVID pandemic going on. So a significant issue. I also, and then to kind of wrap this up, I really want to say, even when you're I really want to state that I think tether should be eliminated for all pretrial conditions. I'm working with a regional professor who has worked on challenging incarceration to say, listen, it's in my opinion, it's like, if a person is such a threat to danger, at least why are we putting tether in this now? I mean, it's either the guy's out or he's in jail. But what I'd like to see done, this is very ideal, is in Denmark and Scandinavia and other parts of Europe, their jail, and I kind of want to make almost like a pre-trial like kind of like a pre-trial detention that's separate from jail, because jail is a form of punishment. You go to jail, it's a very harrowing and horrific experience. And I think for somebody who is really trying to assert their innocence and their constitutional right, they should at least have the protection. Well, if at the minimum the judge says, listen, we just want to put this person on the side. Maybe the guy's, there's substantial evidence showing that this guy committed a murder or a serious injury. There should at least be, and then even for like small minor offenses, that they should be put in almost like a nursing home or like a dorm. And there's pictures online of Scandinavian jails that are very similar to what they would look like, the dormitories. So I leave you with those comments and my experience. And I really hope that there was a push for that. They have a new type of facility, at least for people that the court's so wanting to put a person into detention or into custody, that they do not suffer a jail experience, but rather in a kind of like a nursing home. So this way they have some contact while still being outbound from that. So that's my experience. Thank you.
Thank you, Mr. Baker. Thank you. Thank
Yes.
you for being here, and thank you for your comments. We appreciate it. Next is Norman Kowalczyk. Mr. Kowalczyk, good morning.
Good morning. I'm actually coming as a formerly incarcerated as well. My interaction, well, I'd also like to thank this committee. You guys, I've read your reports, and you guys really do know a lot of the issues that need to be addressed. And I really appreciate you guys taking the time. And apparently you've been interviewing people and studying what's been going wrong. So I appreciate that. Second, these bail reform bills are structured in a way that's going to gather the data so that the public can actually begin to see which judges and which prosecutors are unequal in the way they disperse these bonds. And I think the accountability that these bills will create is critical and would also prevent some of the unintended consequences of the bail system currently. I started off with a simple civil infraction, and I was trying to put myself through school. I was 25 years old and working full time, My bills were barely able to be met. Next thing I know, I get a speeding ticket with a cracked windshield. Couldn't afford to pay it. I had to make decisions in my life, decisions on which necessity I was going to give up. And I chose the wrong one. I chose not to pay the ticket. A month and a half later, I lost my license, didn't know it was gone, get pulled over. Now the police had to arrest me, impound my car, take me to jail. And then during that time, while I was sitting in jail, I lost my car, I lost my job, and I ended up losing my apartment. After I got out, I ended up dropping out of college because I had no way to get there. That was 25 years old. My credit rating was gone, my money was gone, my car was gone. This is what the bail system does. You know, I was waiting on finding out I only had $100 bail. I had to wait. That wait cost me so much more pain, so much more suffering than the offense was. The system is creating situations where the unintended punishments that the bail system and waiting for bail are causing to families, communities, that this is a punishment. I don't know, they say it's for protecting the public, but when you put people in these desperate positions where they are making decisions between which necessity they're giving up, you're creating someone who's desperate, depressed, despondent, and on the tipping edge of losing everything they have. People in this situation will make desperate decisions. That's when people create or do crimes, is when they're in desperate positions. Why are we creating a system where more people are being brought into desperate situations by our government, by our correction system? The correction system that's supposed to be protecting the public are putting people in situations where they make bad decisions. And those bad decisions hurt communities, hurt families, feed people's depression, feed addiction, feed alcoholism, and feed criminal behavior. Why it's taking this long? I mean, there's been decades of these bad programs, these bad systems. I mean, you've created a bail bond system that preys on these people, that go out and makes money on people who are in such desperate situations that their families will hawk their houses, sell their cars, sell their tools for their career, and pawn things just to get a person out of jail so they're safe. When I was in jail, I was intimidated, threatened, things were stolen from me. I mean, we're putting people like this before they're even convicted. This is supposed to be the United States, where we're supposed to be, able to seek happiness. Just getting into the system. I was in prison for 5 years. In that 5 years, I've met so many people that followed this same path. We have created thousands of people we've destroyed their credit. Someone who's 30 years old and you take everything they have, will they ever have a chance to buy a house? Will they ever be able, now they have a criminal record, are they going to be able to get a quality job, a long-term career? I had to start a landscape company again. That's the only way I could find employment, is when I'm self-employed. Some would say that's a good thing. It's been a struggle. Again, I frequently, because I own my own business, I have to make decisions on which necessity I give up. Why in 2020 do we use our systems to put people in decisions where they're trying to decide which necessity? It's like trying to decide which limb are you going to cut off to make it through. Please continue this great work. I mean, I'm willing to go talk to legislators. I volunteer with the ACLU. I don't want anyone to go through what I went through. The pain, the suffering, the 2 decades of loss in my life. I mean, my addiction took me into the system for years. I've ended up costing taxpayers so much money because they wanted a little bit of bond. They wanted to incarcerate me on a ridiculous charge that I was not a danger to society. Please continue your work. Please, if you need to take this recording to the legislature, or call me, email me. Please, I will carry this message. And thank you for your time.
Thank you, Mr. Kowalczyk. You should know that there are legislative members of our committee who are here today listening to you. So thank you for being here, and thank you for your comments. We appreciate it. Next is Alex St. John. Good morning, Mr. St. John.
Good morning, Justice McCormick. Thank you for having me here. I'm grateful for the opportunity to speak today. I'm actually coming from the opposite side of both gentlemen who spoke before me. I have a background in prior law enforcement as well, currently in the bonds industry. I'm here because obviously, even with what I do, I could say that our system does not work. Our system isn't perfect. There's changes that need to be made. But there's always that discussion of how do we do it? What's right? What's wrong? Unfortunately, we get a lot of flack between each other. There's a lot of people who don't understand necessarily what we do in our industry, who think that it may be wrong, who think that it may prey on people. And that right there is why I'm here. I want to clear up some of that misconception. With our industry, we try to help get people out. Now, these days, we're not responsible for setting the bonds. We're not responsible for what happens in the judicial system. We try to provide people a way out so they can continue to live their lives, to do the things that they have to do, to be employed, to see their families. However, what we offer, and this is at zero cost to the taxpayers, is accountability for individuals who may be repeat offenders, who may have, charges after charges, who have been in the system and continue to go, and the recidivism is there. We have that accountability where right now, I do a lot of the, I guess you could say, recovery. So my job is to go and say, hey, you have a warrant, you're not showing up for court, what's going on? And if we need to, we remand them back into custody. We're in a business of working with people. So if it's something simple like, hey, this happened, we'll work with them, get them a new court date. I'm trying to set up a partnership right now with an organization that helps with substance abuse. My job, I come in contact with a lot of people who are suffering from substance abuse, and it's heart-wrenching because some people have fallen in a very dark pit, and they resort to the substance abuse. There's a habit that they seem that they just can't break, and they need that help. We try to get them help. It's not our goal is to say, yeah, whatever, you're here on a possession charge, just go sit back in jail. It's come to the point where myself and my team, we carry Narcan. We have to carry Narcan and I unfortunately had the displeasure of deploying that just last week on a girl who, I'm grateful that I was there and was able to do that, because my concern was that she was going to overdose. But what happens if we weren't? That becomes the question, is that we're there for accountability. We're there to help people. And in a sense, we're demonized because people think that we take advantage, but we do something that right now is not being done. Law enforcement is a stretch thing for individuals who fail to appear, who don't go to court, who don't handle what they're supposed to handle. Now, I can agree with Mr. Mayor and the previous gentleman that the tethers are absolutely, those are a very flawed system. I used to work for the Wayne County Sheriff's Office, where Wayne County has its own tether unit that is run by the Sheriff's Department. I know other agencies, such as like Ingham, Jackson counties, they use private contractors to use tethers, that charge people. Well, so for, say, Wayne County, there's about 7 tether officers that are each assigned about a minimum of 100 people on tether right now. Those people slip through the cracks. People who are letting their tethers die, people who are cutting them off, the non-payment, which is another financial hole that puts people in where, as the bond industry, it's like, okay, you pay money to get out up front, but it's not, hey, you have to pay $60 a day for this tether. And however many days, or weeks or whatever the order may be, you're not required to pay that and to dig yourself into a bigger financial hole. But if you don't go to court and you do not handle what you have agreed to handle, you're held accountable. People like myself come and we say, hey, you know what, this has to get done. And there's so many individuals. Unfortunately, I picked up an individual last night, lodged him to Jackson County on, he was given a $2,500 bond for felonious assault. For felony assault, when I got him to the jail, he had 2 more warrants for breaking and entering in another assault charge that he was waiting to get arrested on, that the sheriff's office was actively seeking to speak with him about. So, you know, there's this line where there's people who, you know, they make a mistake, and that's the thing, is we don't think that everybody's a career criminal. You know, people make mistakes, things happen, people get caught up in the system. And absolutely, it's an imperfect system at times. But you have people who also, to that end, they get involved in multiple cases, have rap sheets, and they just know that all they're going to get is a slap on the wrist. You know, unfortunately, it feels as if there's been judicial discretion taken out of, you know, bond hearings and sentencings, and put into the algorithms that say, okay, well, what should we give this guy? Even though, you know, he's got 18 charges on his rap sheet in his history, you know, who's done prison time, who's done, you know, who's been in and out of the system like it's a revolving door.
Mr. St. John, can you come to a conclusion where you're over your 5 minutes? But thank you so much for these comments. Please feel free to conclude. I don't want to.
Yeah, that's just my thing is, you know, our system, obviously, I can agree being on my side that, you know, it needs reform, but I also don't want to see, you know, an industry that does provide a service that people may not be really truly aware of how it actually goes. You know, don't want that under attack.
Thank you very much for being here, and thank you for your comments. We appreciate you.
Thank you.
Yeah. Next is Sherry Wells. Good morning, Ms. Wells.
Good morning. I submitted a written statement, and it included a lot of what I see since I've had the time to look at what you've already done. But one thing that came to me that I did not include, and I have not heard it covered yet today or in all of the documents, the many documents that show the work you've been doing. Pretrial probation. Now, probation is, my understanding, was supposed to be after somebody is sentenced as part of it, of their sentence. I don't know what happened to innocent until proven guilty. I ran into this only in a circuit court when I was seeing notifications that my client had not been reporting for pretrial probation, pretrial services. And the appointed attorney gave me, I'm sure, everything he had when I came into the case. And I was told that, well, no, attorneys are not notified about these pretrial service reporting things. I do not understand why not. This also goes with the fee, and I'm glad Mr. St. John talked about tethers, because the tether fee is another form of bail, in a sense. My client particularly had kept losing his phone, which meant he couldn't call in. And this pretrial probation is ridiculous. At one point, he was having problems getting a job. I said, well, it says pretrial services. See what they can do for you. Nothing. So I don't know where that came up. I don't know where all it is used, but it is, there's no reason for it. It needs to be dropped. And so that is one more thing that needs to be handled. There's also another minor, well, relatively minor issue, and that's the fact that people in jail are not able to vote. They're supposed to be, but I understand from various people who are trying to get into jails to help people be able to vote are being prevented from doing so. So if people are not locked up, that won't be a problem. And if they are locked up, they need to have access to their right to vote if they have not yet been convicted. Those are my two issues in addition to my statement. And I am very impressed with all the knowledge you've already assembled, and I hope you can carry it through to the goal line. Thank you.
Thank you, Ms. Wells. Thank you for being here this morning, and thank you for your written submissions as well. We appreciate you. We had an additional person ask this morning to speak to us. It's Darrell Douglas. Mr. Douglas, if you are here, I don't know, Emily, if
it doesn't appear that he joined the meeting.
Okay. We also have a couple of other people in the meeting who I don't believe we have identified as media. So I would ask now if there's anybody else who wants to address us this morning. You can just unmute and tell us who you are, if so.
Good morning. This is Nicole Zayas Manzano. Here, I'll turn on my video.
Good morning.
Make it a little easier. Good morning. This is Nicole Zayas Manzano. Thank you for giving me an opportunity to speak. I didn't quite get the confirmation email back, but I submitted written comments last night as well. I'm a senior policy counsel with the Bail Project, a national nonprofit organization that provides free bail assistance and community-based pretrial support to thousands of low-income and indigent people every year across the country. Since our Detroit site launched in 2018, we've bailed out 552 people there, allowing them to return to their families, jobs, and communities, and to fight their cases from a position of freedom. Once our clients are free, we provide them court reminders and transportation to court if needed. As part of our process, we ask clients about their needs and provide voluntary referrals to social service providers inside their own communities. The result, our supported Detroit clients have returned to over 1,700 court dates for a 95% court appearance rate. Seeing how well this community release with support model works on the ground, we fight across the country to end cash bail systems and to create a more humane and equitable pretrial system in the future. Michigan is ripe for exploring this kind of reform. As you know, and have exposed in the past 40 years, the number of people in Michigan jails has tripled, many of whom are there pre-trial. In 2020, Michigan lawmakers were provided a clear, concise roadmap designed by the Joint Task Force to reform the state's criminal legal system. They moved quickly to implement the first 20 bills, and we seriously applaud that effort. But the work isn't done. It's time to prioritize the remaining policy recommendations for legislative action, starting with fixing our broken cash bail system. Fortunately, a bipartisan package of bills introduced last fall in the legislature, House Bills 5436 through 5443, aim to safely reduce jail populations by doing just that. This bold effort would greatly limit the use of cash bail, require judges to consider how much someone can afford, limit overly burdensome requirements for those released, and encourage judges to connect people with community-based social services while they await trial. We know from our work that cash bail was designed to ensure that a person returns to court, but in reality, it creates a two-tiered system of justice, one for people with money and one for everyone else. Of course, the consequences are huge. If you can't afford bail, you face the specter of having your entire life fall apart. You might lose your job. You can't provide care for your children or dependent family members. And we see entire communities missing people, entire swaths of people lost inside the system. And we prove every day at the Bail Project that having money on the line isn't what brings people back to court, it's support. So we really hope that this bipartisan package of bills that has been in the legislature since last fall is the robust solution that we need to really bolster public safety while emptying jails and making sure people who don't need to be there aren't trapped there. I'm really hoping that the legislature swiftly passes these reforms and that you're able to urge them and prioritize this passage as much as possible. Thank you so much.
Thank you for being here and thank you for your comments. Is there anybody else in the room who would like to address us? Mr. Kowalczyk, do you have more to say? We heard from you for 5 minutes.
Just 1 minute. You know, one of the things I think that was missing here was Michigan has a huge percentage of plea bargains in cases. We also are finding a lot of wrongful convictions. I think a lot of what's happened with some of our wrongful convictions is due to the filth, the violence, intimidation, and that happens in the jail cell. I mean, people come out of there with PTSD and trauma. I mean, and the food's horrible. But I mean, some of these people end up so desperate that a prosecutor can offer a plea and claim that they are allowed to go home. You know, the judge will only sentence you to 90 days, and the judge can sentence them for years. You know, a lot of times we have people in there that are so desperate to sign a plea have poor representation, public defenders. I think a lot of times it gives some prosecutors the ability to use that situation to get pleas on crimes that really should not have been convicted or found guilty. So I just wanted to make sure that that perspective is brought. Thank you.
Thank you very much, Mr. Kowalczyk. We appreciate it. So I think we have now gotten through the public comments for this morning, the live public comments. And so I would ask Emily to walk us through the rest of the comments we received in writing.
Good morning, everyone. Thank you, Chief Justice. I'm going to go ahead and share my screen so that you all can see. So we put out a press release as of the 20th of January to solicit public comment both in writing and to provide people the opportunity to give oral testimony today. The council received 68 responses to date. And of those 68 responses, there were a couple of very pertinent themes that were displayed across those responses. The most prominent one was the discussion of voting rights and education being available to individuals who are housed in county jails. A close second was support being expressed for those pretrial reforms that are currently pending in the legislature. We also saw some frequent comments regarding jail alternatives and mental health programs, as well as additional diversion programs to jail. And then a couple of other important themes that came up were specific progress within the implementation of the reforms that have already passed, data collection and standardization across the state, and a localization versus a statewide judiciary. And this is just kind of the breakdown from top to bottom of the themes and some of the frequently occurring comments that were coming up. So voting rights of incarcerated individuals was one of the most commonly cited themes throughout the comments. The idea that's coming up is that they're wanting to make sure that there's access to education as well as people's voting rights are staying intact during the time that they are incarcerated. So here's a couple of the comments that were received by the council. And all of these comments are included in the summary that was put out to council members this morning. Pretrial reform was another commonly mentioned theme throughout the compiled comments. The House Bills 5436 through 5443 are currently pending in the legislature, and we received comments that were expressing additional support for the passing of those pending bills. And so again, a couple of comments that were received by the council also contained in the summary that was put out this morning. Mental health services and diversion programs was the other pertinent theme. Additional comments received to discuss the importance of mental health as a diversion program, as well as services being made available to individuals who are requiring them while they are incarcerated. Again, some additional comments. Data collection and standardization was discussed, especially in regards to bail reform and the pretrial bills. There seems to be an apparent desire for a statewide data system to be able to track criminal justice data, as well as utilize that data to analyze the effectiveness of the reforms that have been implemented. We received a comment from an IT professional out of Macomb County with some suggestions on how to improve data collection and standardization. So again, that comment is contained in the summary that was provided to the council this morning. Some additional comments that came in, we received a comment from retired Senator Bruce Caswell suggesting that the Criminal Justice Policy Commission report be reviewed. We also received some comments regarding felony murder law and asking for some recommendations to be made on behalf of the individuals who support that initiative. So if you would have any additional comments or questions regarding comments, please feel free to reach out and let me know. And going forward, as we continue to receive comments for the council, those summaries will be provided to council members on a monthly basis.
Thanks, Emily. Are there any questions for Emily about the written comments? Excellent. Let's move to the next part of our agenda. We wanted to have a discussion about Senator Runstead's memo. Is Senator Runstead present this morning? I don't see him.
I don't believe so, Chief Justice.
Okay. Council members will recall that Senator Runstead sent a memo with some what seemed to be additional public comments. So it made sense, we thought, to discuss what, if any, action or next steps we might want to take on those comments. One idea is whether doing stakeholder surveys is something that the council members think is a good idea. I mean, qualitative data has a role to play in telling a story and understanding how the public experiences our legal systems and the subparts of them. And so stakeholder surveys are a tool that we used in the task force to understand what different groups of people were thinking about the way the jail system functioned. Of course, qualitative data is not the same as quantitative data, and we still really want to figure out all the ways in which we can collect quantitative data to evaluate how the policy changes are working on the ground. But I would open it up to council discussion about the issues raised by Senator Runstead's memo and any ideas about stakeholder surveys or other ways in which we can be figuring out how to collect data. So I'm kind of merging two agenda items.
Hi, this is Heidi Washington. I have Russ Marlin, who is my Deputy Director for Field Operations on, and we could comment just briefly, just to clarify some of the actual practices that are going on in probation as it relates to some of the comments that were made. And so if you would be interested in hearing that little small bit of information, we'd be willing to comment on that.
Yeah, thank you, Director Washington. Mr. Marlin, please unmute and tell us what you got.
Thank you, Chief Justice and Director. I just really wanted to provide some comment on one of the things brought up in the memo, where it was about the public safety issues associated with the absconding language in the bill. And I just want to be clear that we have an operating procedure on how to handle absconders under our supervision, whether that be parolees or probationers. And that is how we've handled it for many years. And so when the bill came out, and I think the senator expressed some of it in some concern in his memo about the 60-day period, we instructed our staff across the state. There's also a line in that bill that allows for an exemption to that 60-day requirement. I think it's in Section 4B, paragraph 7A, where it says the probationer presents an immediate danger to himself, herself, or another person or the public. So our procedure is not to ask for a warrant or issue a warrant in the case of parolees simply for failing to report. We have a series of steps that our agents go through to bring that person back into reporting status. That includes visiting their job, visiting their home, making collateral contacts with their family, searching social media sites to see what the person may be up to. It's not simply they missed a report day and we're issuing a warrant. And then, so they go through those steps, and within 5 days, they ask the judge for a warrant, or we issue a warrant for parolees. And so the instruction that we sent out to our agents across the state is to utilize that line in the bill and process absconders as we've always processed absconders. So that is, I just want to provide that clarification because they mentioned the letting someone, basically run around for 60 days without issuing a warrant. And we have had a few judges that asked about that language in the statute, and we haven't given our agents information to respond to the judges that this is the process that we will be following.
Thank you for that information, Mr. Marlin. Any additional discussion from council members about our data collection ideas? We have a subcommittee our subcommittee so far is Barb and Melissa, which is a great subcommittee. But if anybody wants to sign on with Barb and Melissa and Emily and Ryan and I, we would like to have you. Oh, Debbie, hand raised. Debbie King.
Hi, thank you. I would be happy to volunteer. One of the things I would suggest that through the Division of Victim Services that we could be helpful with is also getting the voices of victims and input from victims about their feelings on bail and bond and all of those issues as well. And I think it won't surprise the group that there will be mixed opinions. Often we see in intimate partner violence situations that the person who may be in jail is the very person that they're dependent on for taking care of the family financially and otherwise. And in other cases where the crime is more random, victims obviously often have a very different take. But I would be happy to be part of the work group and make sure that we're able to hook up and help survey and that kind of thing, the voices of victims.
Thank you very much for that. Barb, you have your hand raised.
Yeah, thanks, Chief Justice. So I guess I appreciate Senator Runstead's comments and the suggestion of the survey. But as you've already, indicated, that's a lot of, qualitative data, which is important. But we've done a lot of that work. And I think moving on to the quantitative data is important. Although, I recently, our Office of Community Corrections here did have a data request from Senator Runstead. And so I think they're beginning to understand just the issues that we face when people request data, because it's not, you just, like you see on the TV, people are like, oh, you need that, and they press a couple of keys and out, comes all this data. It's not like that at all. As you know, each of us collect our own data, and then trying to link that data together is very, very difficult. I was very happy to see in the governor's recently released recommendations that there's several $1 million for a statewide, data system. And so I think that that's what we need, to work towards, because surveys are great, but it at the end of the day, it really doesn't tell us what truly is going on in the system. And that's what we have to continue to work towards. I guess just the other thing, if I can, I'd like to make a comment. I appreciate everyone who spoke at public comment here today. And in particular, an issue that was brought up by Ms. Wells, pretrial probation. And I think one of the things that the bail bills is missing is the standardization of pretrial services or the locus of where pretrial services would reside. What we often see is we have a county-run pretrial services, and we follow national standards and best practices. However, several of our district courts have started their own pretrial services, and those generally tend to be much more onerous and are run out of the probation department. And so they treat it like probation. And so when we hear these conflicting stories about pretrial services, I just think that that's something we need to keep in mind, that, some courts have just gone on their own to run pretrial, and I don't know that they're following any, national standards or certification.
Thanks, Barb. Any other thoughts or comments from council members on data collection? Okay, well, thank you everybody for showing up, especially those of you from the public who showed up to give us a perspective that we wouldn't otherwise have. So we are grateful for that. Our future meeting dates, our next meeting is March 18th, also at 9 a.m. And if there's no further business, I will adjourn today's meeting and give you some time back. Thank you all for your continued work on the council. Have a great day, everyone.